All right, we shall reconvene. I'm delighted to introduce Marcy Wilder, the co-head of the privacy practice at Hogan Lovells, and somebody who's worked for years in this area. And Marcy will introduce our other panelists. So thank you, Marcy. The podium is yours.
Good morning. It is a pleasure to be here this morning to talk about the secondary use of de-identified data following on. I think it's a good follow-on to the first panel. We have, let me introduce myself first. I'm Marcy Wilder, co-director of the Hogan Lovells Privacy and Information Management Practice. And I have been in the world of de-identified data for about 12 years. I was the Deputy General Counsel at the Department of Health and Human Services and was the lead lawyer on the Hipaa regulations. So was involved in one of the early efforts to actually create a legal standard for de-identification, which may in fact be the only legal standard for de-identification that exists right now. We have three panelists this morning that are going to talk to us both about de-identification processes and how both the public and private sector put that data to use in some of the policy challenges involved in trying to weigh and balance just how de-identified does data need to be before, in fact, we put it to various uses. So first up this morning is Harlan Yu, who is a PhD candidate in the Department of Computer Science and the Center for Information Technology Policy at Princeton. And Harlan is going to talk about the use of de-identified data and open government. Second up, we will have Mitra Roca from the FDA's Sentinel project, and she is an expert in the use of de-identified data for public health and research purposes as it relates to a relatively new but very significant FDA project, the Sentinel project. And third up, we will have Dan Barth Jones, who is a professor. I know him in his professional, not professorial capacity, but is an assistant professor of clinical epidemiology at the Mailman School of Public Health at Columbia University. And he has worked on de-identification issues for quite a long time and is one of the leaders in the field on statistical de-identification methodologies. And he's going to talk about the use of de-identified data in the private sector as opposed to our two other speakers who will talk about the government sector, and he'll also address some of the methodological issues and policy issues involved in those data uses. So without delay, I will bring up Harlan and we'll get started.
Morning. So in this panel, we'll be talking about common secondary uses of de-identified data. And the angle that I'd like to approach this problem this morning is from the open government perspective. And so the government itself at all levels, at the federal, the state, and the municipal levels, all collect large amounts of data itself. And needless to say, much of the data that the government collects is of broad public interest. So think about labor and economics data, public health information that we're going to talk a little bit more on this panel, and crime data and how public monies are spent. And the presumption for a lot of this government data is that these government collected data sets ought to be released to the public. And in general, publishing government information is advantageous for two primary reasons. First, for transparency and accountability of our democratic institutions to increase the trust between citizens and our government. And two, because much of this data is itself very valuable and already paid for by taxpayer money, it should be available to the public for downstream commercial and nonprofit uses. And with the recent open government movement, the idea is that the government should not just release aggregate statistics and reports that are useful for some limited purposes, but to actually release all of the raw data that allows the public to recombine and remix and otherwise analyze these large data sets in any way it sees fit. And so the public can realize this range of downstream benefits, whether it's to root out corruption in public spending, to launch entire new industries like the GPS and weather data have done, or for private industries to help citizens better understand the government and its services. But in practice, and it should come as no surprise, it's often very difficult for the government itself to publish these raw data sets and realize these benefits because there's so much sensitive information in these data sets. And this is especially true when the expectation in open government is that this data ought to be published in an open way, without any kinds of licensing, terms of use, or other kinds of intellectual property restrictions. And so for this kind of data, I think it's very difficult to have data use agreements like we have with health data and Hipaa. And for many kinds of other data, like our common law, for example, data use agreements don't make that much sense. And so the example that I want to focus on today is with electronic court records. And so these are all of the written records of our judicial system, the complaints by accusers, filings by attorneys, and decisions by judges. And obviously, because the judicial system touches on so many sensitive aspects of our society, imagine bankruptcy cases, divorce cases, domestic abuse and immigration. Large amounts of sensitive personal information are in these records. And so while it's technically possible to get these public records, and they're available for inspection by the public, what the courts have relied on in the past, and in some ways have stumbled upon this policy of practical obscurity, which Professor Swire talked about this morning. And what this means is that you can get these records if you physically travel to the courthouse and pay the copy costs and ask the clerk for specific limited records. But on a wide scale, it's actually very difficult to obtain the whole corpus of these records. At the federal level, the US courts run a system called PACER, which is public access to court electronic records. But one of the issues with PACER is that they charge money. They actually institute a paywall where they charge 10 cents per page for the public record, for the common law. And this actually extends practical obscurity from the courthouse physical world into the electronic world. So as a result, while it's technically possible to get some of these documents or any one of these documents, and leaving aside the issue for now of sealing individual documents or cases as a whole, getting these records is either very expensive or impossible. And so for court records, these records are littered with social security numbers, numbers of financial accounts, names of minors, names of informants, and other sensitive information. And only recently, in 2007, have the federal courts instituted privacy protections for filings made by the court. And so in the Federal Rules of Criminal Procedure, Rule 49.1, says that attorneys who file with the courts need to redact 5 kinds of information. So one is to redact the last 4 digits of the social security number and financial accounts, redacting the year of an individual's birth. Any minors' names need to be redacted, replaced only with initials, the last 4 digits of financial account numbers, which I talked about earlier, and the city and state of any home address. And so these are quite primitive protections, and certainly, I believe, inefficient today, given what we know about data re-identification. And there's similarly primitive redaction rules in the Federal Rules of Civil Procedure. And so the risk of publishing these sensitive data within court records is that you might get sites which exist today like who'sarat.com, which is what they claim to be the world's largest online database of informants, of police informants. And so you can imagine, and they actually do get a lot of their data out of federal court records and state and municipal court records that are not adequately redacted. Other kinds of applications that you might have for this sensitive data that's released out in the public in the name of transparency are apps like datecheck.com, which is an iPhone app that allows you to quickly do background checks on your dates on the go. Or maybe more important is that people don't want these cases to show up on the first page of the Google results when they search their names. And even for people who are innocent and have been exonerated of their accusations, having these cases up on the front page when people search their name actually may lead to bad impressions that may be bad for society. And so I think in essence, the main impact and the main risk is that fewer people will feel comfortable using the justice system because people might assume that just by being a litigant, this means that these cases will be linked to their names online in perpetuity. And I think this would be quite bad for a democracy. However, on the flip side, the advantages of using de-identified data from court records is quite significant. Among other things, it would improve trust and accountability in how justice is dispensed in our democracy. It would improve legal research tools and perhaps make legal research tools cheaper and more accessible to more individuals. And it would also spur more research into the judicial system. For example, longitudinal studies across all of our federal courts in terms of patterns of how certain areas of the laws have changed, or differences in how judges rule over time in various types of cases. And so it's clear in our judicial branch and in other parts of our government that we need better and more rigorous mechanisms to balance privacy and their obligation also to provide transparency into their activities. And it's not just with new documents. We could have a rule today that has that provides better privacy protections for documents that are being created today, but at least at the federal court level, we actually have a huge backfile problem where the courts already have about 500 million electronic records that are, again, littered with sensitive information. And so this is just one example of a government data set, but I think it's a stark one and different than some of the other examples that we're going to have today, because these records are common law. In a democracy, citizens ought to have open access to the laws that we're required to obey by. But under these concerns about data de-identification, these actually pose a critical roadblock to the publication of our law in an open and equitable way. And so to switch branches of government to look sort of more broadly at the rest of the federal government, at the executive branch, much of the open data has been published under the Open Government Directive, where all agencies have been publishing more data, public data sets in data.gov. And one of the final steps in publishing data on data.gov is a privacy and security review. And from what I understand, this is just a small committee of individuals in the National Security Council who review data sets for potential mosaic effects, which is the government term for de-identification, for mosaic effects occurrences in these data for privacy or national security reasons. And needless to say, this also is not very rigorous. And so I think as a result, agencies publish open data about their activities in a very conservative way. And there's lots of valuable data that's still hidden within agencies that would be useful for the public if we were able to better think about and protect private information in these data so they can actually be published. And so outside a few pockets of our government, there's no real cohesive strategy for de-anonymizing data that makes data both available and useful to the public while protecting the data against re-identification attacks. And so coming up with a cohesive strategy that scales to all the diverse kinds of information that the government collects and also accommodates the maximal range of downstream commercial and nonprofit uses, I think will be quite difficult and certainly very expensive as a challenge to the government. And the challenge, I think, is not just how to de-anonymize data, but how to do so at a reasonable cost within the bureaucratic structures of our government institutions and to be able to provide more of this data to the public in the future. Thanks.
Good morning, everyone. I am the Medical Informatics Lead on Fda Sentinel Initiative, and I'm going to provide an overview and update of where we are with the Sentinel Initiative. So FDA Amendment Act of 2007, Section 905 mandated FDA to have develop the Sentinel Initiative and establish a risk identification system to analyze the safety issues that might occur from medical product that FDA regulates. This could be biologic, vaccine, drugs, or devices. And then also within the Section 905, they have stated that FDA should have access to 25 million patient data by July 2010 and 100 million patient data by July 2012. And also within that mandate, they have stated that we have to, FDA should have access to a wide variety of data that is both the public data from other federal government agencies. For example, we are collaborating with Department of Defense and Veterans Health Administration, utilizing their electronic health record data, and CMS, Center for Medicare and Medicaid, using claims data. And also with private health plans such as Kaiser Permanente, Aetna, Humana, and United Health Corps, and also Vanderbilt, which has Tennessee Medicaid data. So when you see the check marks, those are the goals that we have achieved. So Sentinel Initiative was launched in May of 2008, and the goal is to improve FDA capability to identify and investigate safety issues in near real time by looking at observational data, both claims and electronic health record data. And also it enhances FDA ability to evaluate safety issues that are not easily investigated in spontaneous or passive adverse event reporting system. So FDA has a system called AIRS, that is adverse event reporting system, but that is passive surveillance. So the physicians fill out the MedWatch form and they send it, but it's volunteer reporting. So Sentinel will expand FDA access to specialty population, for example, pediatric or elderly, and it also enhances FDA access to longer-term data by having access to electronic health record data. And also, there might be a common adverse event that might not get reported through the spontaneous or passive adverse event reporting system to FDA, for example, myocardial infarction or fractures. So here what is important to note is that Sentinel is not going to replace the existing safety systems at FDA, but it will augment them. So Sentinel is a collaborative effort, so we have to work with the private health plans and utilizing their observational data. We have a pilot called Mini Sentinel pilot, and with the public data, we are working with Department of Defense, VA, and CMS. And Indian Health Service is also interested to join the Sentinel initiative. And then at industry, there is an initiative called OMOP, or Observational Medical Outcome Partnership. This is a public-private partnership, and it's funded by Foundation of NIH, and they are looking at innovative methodological research for active surveillance. And then we also have a cooperative agreement with Brookings Institution, and they have topics on active surveillance through the year for us. So Mini Sentinel is the pilot for the future working Sentinel initiative. The contractor is Harvard Pilgrim Healthcare Institute, and the goal is to develop the scientific operations needed for an active medical product safety surveillance system. And so Harvard Pilgrim has built a coordinating center, and they have access to electronic healthcare data system. And so they act as a lab for us for developing scientific methodology that is needed for active surveillance, and also they offer the agency the opportunity to investigate safety issues in this electronic healthcare data. And we also learn about barriers and challenges, both internal and external, with this type of data. This doesn't work. Okay, so this slide shows the flow of data from when FDA asks a question. So at FDA, we come up with a query or question of interest. It's usually a pair. So it's a medical, like a drug. I am at Center for Drug Evaluation. So it is a drug and an adverse event. And then we send our question to Harvard Pilgrim or the Mini Sentinel Coordinating Center, and they take the question from FDA and they use SAS, which is Statistical Analysis System, and they write the software code. And then they send that code to the participating 18 data partners. These are like 7 Kaiser Permanente, 9 HMO Research Network, Aetna, Humana, United Healthcare, and Vanderbilt. And then they run the queries behind their firewall, and then they only send back to Harvard the aggregate de-identified data. And then the Harvard Pilgrim shares that results, the summary result, with FDA. So for Mini Sentinel, we have been working with Brookings Institution, and we have a privacy panel looking at the patient privacy issues. And Sentinel is not clinical research, it is public health surveillance, and FDA is a public health authority. So OHARP has stated that Sentinel activities are not governed by the common rule. And moreover, the disclosure of PHI to the FDA, the Mini Sentinel Coordinating Center, and the collaborating institution is disclosure of PHI to public health authorities, and thus does not require IRB or individual authorization. So, and then the other principles and policies we follow is to minimize transfer of protected health information. So what FDA receives is only de-identified aggregate summary results. And then the data partners, they participate voluntarily. And in order to maximize transparency, all the tools, software, programs, protocols, methods are, and the findings from the protocols that get developed for the medical product that are under investigation and the adverse event, they all get uploaded on Harvard's website, minisentinel.org. So, is everything? Thank you. Thanks, everyone.
I wasn't planning on not being able to see my slides. Well, I think actually this will work. I'll just be, rather than put this up, I'll crane my head around to be able to see what's up there. So let's start with the first set of slides for me. Okay, so I'm going to be talking about commercial uses of secondary uses of de-identified data. And commercial is in quotes because in actuality our data collection system that exists in the United States right now, even for many other purposes such as research, public health operations, etc., much of the information is chained through the data collection that goes on, at least initially, in a commercial sphere. Next slide. I'm sorry? Oh, I've got the clicker. Okay, there we go. So public health, de-identified data creates an invaluable public good. And so when we talk about privacy risks, we need to always be balancing that against the public good that goes on with this, the use of this data. And so everyone in this room, although you in many ways are not aware of the ways in which you have benefited from de-identified data, you have. Some of those ways have been examples like the Sentinel service, which is monitoring drugs that you're taking for adverse reactions. Some of those are more practical efficiencies in the healthcare system that come from knowing where a good placement for a healthcare facility is based on information about zip code information from individuals. And so it's the engine that drives forward a whole variety of health systems planning, initial analyses that support healthcare fraud, abuse, and waste detection, public health research, adverse drug event monitoring, cost effectiveness research, and even determining whether there are health disparities that exist between different racial groups and why those exist and what can be done to remedy those. So these benefits are very high, and the promise with the advent of electronic medical records is that these benefits will only become more important. This really will be the engine through which much of the ability to achieve healthcare reform in ways that increase the efficiency and the quality of our healthcare system will be realized. So one of the problems if we don't go the route of de-identification and if we require individual authorization is that numerous studies have shown that we can have very severe selection and information biases in terms of who will agree to allow their information to be used. And unfortunately, this creates the situation of what we call consent bias. Unfortunately, some of the information that we would need to adjust for these biases in an epidemiological sense are the very same pieces of information, age, gender, race, etc., that we would need to redact in the process of doing de-identification in some cases. So we have a fundamental conflict here. I think we achieve a good balance here under de-identification, but if we were to go to an opt-in situation where people only had their data used when they agreed to do it, we would have abysmal response rates and severe biases. If we go to opt-out, that's in the realm of perhaps workable, but there are certainly challenges with biases associated with that as well. Now, I've shown this slide a number of times before, and it shows, this is my inconvenient truth slide, and I'll give you my Al Gore moment here. We can either have optimal precision and lack of bias in the data that we have, or we can have complete protection, which would be no data release. And for any particular set of data, we're facing a trade-off between those things. And the more that we try to anonymize the data by making groups of individuals similar before we report their results, we operate on this curve. And so we may find an optimal trade-off point where we get a great deal of privacy protection with little decrement to the quality of the information that needs to be used for a research purpose, but we have to function on this trade-off because we can't simultaneously have all the information released and complete accuracy of the statistical and research analyses that we want to perform. It's an unfortunate situation that many popular de-identification methods, for example, k-anonymity, which tries to make all observations have k or 2, 3, 20 other observations all share the same characteristic. If you do that, you destroy multivariate statistical analyses because you destroy the variance covariance matrices and you can mask various heterogeneous groups. And so if you're lumping all races, for example, other than Caucasians and African Americans into one other group, there might be a great deal of diversity in that other group that you're no longer able to detect because you've made them all similar. This problem is very well understood by statisticians and by computer scientists working in the sphere of data analyses, but it is not well incorporated into public policy. And so we have the potential to head down the path to bad science and bad decision. And what's even worse in this scenario is that with data that's been poorly de-identified, analysts who are working with improperly de-identified data will not be able to recognize the distortion in their results. So I want to talk about two myths about Hipaa de-identified data. All of my uses will be in the realm of healthcare data, which is the domain that I work in. One is the idea that it doesn't work. There was a paper by Paul Ohm that's already been mentioned that says re-identification is easy, cheap, and powerful. The situation in terms of pre-Hipaa re-identification risks is that we could identify somewhere between 87 to 63% of the population just on the basis of their 5-digit zip code, their birth date, and their gender. That is no longer the case now, and HIPAA-compliant de-identification provides important protections. The estimate that Dr. Sweeney had provided in testimony before the National Committee for Vital Health Statistics in 2007 was that approximately 4 people in 10,000 could be re-identified. And in a more exacting analysis performed by Dr. Malin and his colleagues that also included the state as one of the stratifying variables, we found somewhere between 400 to 1,000 times more protective than having someone look at your protected health information directly. Now, this is not 10 times better. It's not 100 times better. These are many thousand-fold protections that we're receiving from the fact that we've removed the direct identifiers. That doesn't say someone cannot attempt re-identification and rarely be successful, but the idea that someone would even attempt re-identification under circumstances when it's so unlikely that they would be able to find an individual needs to be further examined. So the counter to that first myth is that de-identification functions perfectly and permanently, and that certainly is not the case. We can't perfectly de-identify information. De-identifying does not free it from all future privacy concerns. There may be once something is de-identified, new data in the future may make data that was once de-identified possible to be re-identified in the future. And it's also the case that by collapsing your categories until they're k-anonymous, you can destroy the statistical properties of those data sets, causing damages to the decisions you're making based on analyses with those. So one of the things that I've been working on is the implementation of qualitative policy analyses for de-identification policy. The idea is that we need to balance these important risks between the benefits that come to society from being able to have programs like the Sentinel program and those risks that individuals face in terms of re-identification. And we have to recognize that there are a very complex set of social, economic, and political motivations that can cause people to attempt re-identification. And so the methods that are being used here are the same sorts of methods that are used by the EPA or by the Energy Department. For example, the Energy Department can't afford to have a number of nuclear reactors melt down to figure out what the risk of that is. They have to work with substantial uncertainty on the failure rate of each component and then combine those estimates to say, what's the probability that we will have a 3-mile island event here? So these are also motivated because we need to anticipate future and evolving re-identification risks. We need the fact that getting an empirical confirmation of re-identification risk can take decades to become realized. Sorry. Okay. The lack of systematic explorations of the full range of quasi-identifier sets. So if we have the risk involved in a 5-digit zip code is dramatically different from the risk of a 3-digit zip code. But the risk of a 3-digit zip code still has important risks because the 3-digit zip code is designed to deliver the mail. And these don't form consistent areas. They are many times broken up into discontiguous parts, and unless we look at the geography associated with that, we don't have any idea what that whole range of potential risks could be. And so we need systematic exploration of combined quasi-identifier sets. What are the combinations of things in the data that can lead to re-identification? And then the level of documentation and the lack of data access has often made it difficult for scientists to replicate each other's work in this area. And so that's another reason why these sorts of policy analyses are helpful. And by using both a cost and benefit type analysis, we can take into account the issue of not only what are the risks of re-identification, but what are we costing ourselves in terms of the availability of public data. So the use of something like a Latin hypergrid, where we search a broad range of parameters, where we have many unknowns that could impact whether a re-identification attempt is realistic and economically viable, is an important route to follow. And this kind of approach follows neatly from the sort of reasoning provided by HHS and their allowance of the 3-digit zip code in the safe harbor, they take into account issues of the entire data release context. And so we need to look at what not only is what is the probability of re-identification given that it's attempted, but what is the probability that re-identification would be attempted. If we do this correctly, re-identification should always be something that is very difficult to achieve. It should be expensive, it should be time-consuming, and it should take into account the motivations of the anticipated recipients of the data. So we can characterize the probability of an attempt based on the resources that are required for a re-identification attempt. These can be quite a barrier. The re-identification, the access to the data necessary to accomplish this, the types of attack methods, the various quasi-identifiers and in their sets and their properties, and the fact that various types of data change over time, and therefore it becomes very difficult to successfully re-identify individuals with accuracy. And also to look at the consequences and alternatives for goal achievement. So one of the scenarios, for example, is that of a nosy neighbor. You're looking for someone known to you or perhaps a specific target, and in a nosy neighbor attack, there's a point at which you might elect not to spend $50,000 and 2 weeks with a team of scientists attempting a re-identification. You might decide that at 2 a.m. you're going to go out and dig through your neighbor's trash to try and figure out what you want to know or ask questions around the neighborhood. So at some point we have to balance our scenarios against how else might someone practically go about trying to find this information. Marketing attacks try to identify as many people as possible in order to market to them, and they conceivably could tolerate much more of error in correct re-identifications. So these various data intrusion details, the motivation, the resources that are necessary, the attack methods that are used, what are the quasi-identifiers, how much does the data change, all come together. And the point being that in order to get a successful re-identification, if we don't have one unique person in our sample data and one unique person in our population, we've not definitively re-identified that person. If there's even just one person missing from the population data that we're trying to match to, we've got a 50% chance that we've correctly re-identified those individuals. Voter registration lists nationwide, we have about 70% of people are in those lists, and so that means people have to invest in the purchase of commercial data to try re-identification attempts. And there is this problem of data divergence. People move, they have changes in their marital status, income levels, etc. And so it is quite possible that we never really re-identify. When we don't check whether people have been correctly re-identified, the presumption that they are may indeed be in error. So using these kind of methods, we can sample from probability distributions about all the things we're uncertain about. How likely is a prohibition on re-identification to decrease the likelihood of attempting re-identification? And that can allow us to look at different scenarios. So the idea of a demonstration attack in which you've got an academic or you've got a disgruntled individual trying to impugn the de-identification method can be compared, for example, with the likelihood of a nosy neighbor effect, where if you already have a probability that's 1 in 10,000 that you can re-identify somebody, it's unlikely you're going to invest the time to try and search for anyone in that data set. So that concludes my presentation, and I think it sets up a framework in which we can realistically try and look at all of these things that we have a great deal of admitted uncertainty about, but it's reasonable to try and quantify out of this entire range of uncertainty about a re-identification attempt being made. When we combine all these things and we search through the sample space, do we still find that this data is appropriately protected with very small re-identification risks? Thank you.
So thank you so much to the panelists. Before we go to Q&A, I thought I would kind of bring these three presentations together, because I actually think they form a relatively coherent whole, and that would set the stage for some discussion. And that is, we started by Harlan talking about how the courts and federal and state government should, in a democracy, make data available to the public for all kinds of uses that will benefit society, but bad things will happen if you don't appropriately de-identify it, be it that individuals will be discouraged from using the court system, or in some real-life examples, identity theft will occur if the Social Security numbers aren't appropriately masked. Mitra then came up and talked about, gave us an example of the government making use of de-identified data for a public purpose or a public benefit, that is monitoring drug and medical device safety, and gave us a real-world example of how public and private data could be made available without being put at risk, and that is by setting up a system whereby the user of the data submits queries, and those queries are run behind the firewall of the data holder. And the results, or aggregate or de-identified data, is then provided to the government in this case in order to make use of it for a public benefit. And that seemed like something that certainly wasn't happening in other sectors of government, for example, the courts or the Defense Department, but maybe perhaps serves as a model of Congress enacted legislation saying make this happen, and was thoughtful, and the agencies were thoughtful about how they might implement that. And then Dan came up and talked about the fact that we've seen we've seen what can happen when large de-identified data sets are made public. Bad things can happen. And he talked about having a legal standard that attempts to strike the appropriate balance of making data available and at the same time intentionally or mindfully tolerating some risk. And of course the hard policy decision is, well, how much risk do we tolerate, and in what context? And I think in the end he told us re-identification should be difficult and expensive, and if we can accomplish that and consider the appropriate factors, there may in fact be a pathway forward. So I think that provides a nice framework for thinking about the de-identification of data and secondary use, and I would like to open it to the floor for questions. Yes.
Hi, I'm Jay Sexton from Correlate. For Dr. Mark Jones, how do you think, cryptographic techniques and things like secure multi-party computation, things that don't necessarily rely on data obfuscation, but have sort of that inconvenient truth curve there, actually toward the upper right, that can offer near ideal privacy and still allow you, pretty much all the statistical methods that you would want to apply. How do those, factor in? What do you see as the future of those in the uptake of something like this?
Yeah, I think that is the future. I think if you wanted to transform our whole medical system right now, analysts who are working with SAS on their own desktops with their own data sets would immediately grind to a halt if that had to be in place everywhere. And we certainly don't want to stop the progress that we're making at this point in time. I think there are solutions that involve computation distributed across parties that preserve privacy, and when we get there in the future, I'm going to be a happy person because I can stop worrying about these re-identification risks in the same way that I have to now. Yes? What time?
I just want to follow up on what he's saying. Even though the first panel was all about re-identification risk, we actually found that sweet spot that you considered impossible in every single example ever brought to us. So in all of the re-identification experiments that we had, most of them included find us a solution. And we were able to find the sweet spot exactly the way he just described, and exactly the way Ann Cahokian talked about in the beginning. The technology is really disruptive, and it's a game changer. And the conversation that you had in your talk is rooted in a 1970s model that data are static, and I've got to address things that I do to this field. But technology, you don't have to do that. We have many solutions, and I would challenge you and anybody else. We'd be delighted to demonstrate to anyone that we identify the risk, and we will find you a workable solution.
I agree that there are workable solutions, but they're always constrained.
And also, that those workable solutions tend to be in that sweet spot, and those workable solutions are usually less expensive than trying to stay minding the status quo. In the same way that Google and Facebook have been disrupted, that's the kind of technology we need to run.
Next question.
It seems to me that at least part of the problem in this debate and discussion is, at least to my mind, a very narrow and somewhat peculiar view of risk that's being taken. It's peculiar in the sense that the focus is almost exclusively on the risk of a specific kind of information control failing. If I'm doing information security, to take a related but distinctly different field, before I even get to the issue of controls, I'm doing a lot of analysis regarding threats and vulnerabilities, and I've got a risk model of some kind that I'm using to try and translate those into a set of risks that I may or may not need to apply some set of controls to. All right, and then once I've done that, those controls hopefully will work properly, but they also might fail for any number of reasons. And so if somebody re-identifies a de-identified data set, that specific control has failed. But that's a different issue than what is the appropriate set of controls that I should be applying to my set of risks. And it's further complicated by the fact, or maybe it's simply more evidence of what I think is the too narrow focus here. It's owing to the fact that privacy risks, certainly in this discussion, it has this kind of this tunnel vision aspect to it. It's all about identification, identity, identity, identity. What it's really about is information leakage. And information leakage, as a couple of the speakers have actually alluded to, can take place in a variety of different ways. And the harms that result from that information leakage may or may not have anything to do with identification. There are privacy harms, and Dan Soloff will probably speak to this a little later. There are privacy harms, a whole family of privacy harms which have little or nothing to do with identification or re-identification. So, what can be done to expand this discourse to get us out of what's almost seeming like a rut these days, where the focus is on identification as the sole privacy risk, and the focus is on the risk of that specific control, i.e. de-identification, failing, as opposed to dealing with a larger set of risks and a more comprehensive set of risk controls.
I think the main reason for the focus on identification is that is usually the way through which attributes and information leaks occur. If you don't know the person's identity, it's much more difficult to attribute inference of a particular attribute. So that's why we're at that stage in the game. I agree that there are different inferences that can be made besides just identity, but if you keep people from being re-identified in data sets, that's the mechanism through which most informational harm occurs.
Yes.
Well, building on Latanya's comment and this gentleman's comment, we really are being much too narrow in thinking about issues only of identifiability. It's one tool in a very large basket. We're concerned, I mean, we're way beyond that now, where marketers don't need your identity in order to be able to do good marketing strategies, because they identified tribes. Stephen Baker's work on the numerati is very illustrative in this regard. But also around risks. We don't need to know who you are if we know some pattern about you. An insurer knows profiles. And again, it's not the individual who's just at risk. It's everybody who's like that individual who's at risk of discrimination and of marginalization, or being denied loans and so on and so forth. So it's not just individuals. We've got to get beyond thinking about individuals.
But at the same time, if you're going to stop making inferences about characteristics of people, speaking as an HIV epidemiologist, I'll tell you what a real group harm is. It's not catching the next HIV epidemic when it occurs. And so there are real important uses of de-identified information for our public health good that I don't want to see sacrificed in the process of trying to protect against group harms.
No, it's not either or. It's all the above. We do these collectives of protections.
But is the point, is the point then that re-identification of an individual is one specific harm? It sounds to me like you're trying to broaden this, when you say we're way beyond re-identification, to say when we have the availability of large data sets, it's possible for folks to derive, it's like you're deriving attributes and then applying them at the individual level, which can have bad effect, discrimination, or good effect, some people would say more relevant ads. And so it's taking the basic concept but then broadening.
Well, there's a public benefit to making the data available. The strategies we have for making them available are not just de-identification. There's a whole range of governance tools to be used. And it needn't be that data are actually released. Data could be kept in enclaves. There could be secure access from remote positions. There are the data use agreements. There's all sorts of things we have, including an underuse of laws that can really penalize the person who intentionally breaches any agreement that they have. I mean, there's a huge range of tools, and we keep focusing in on identification risk and de-identification tools. It's only one part.
You know, I think it would be interesting actually to hear from Harlan on how these various tools that are being discussed apply in the research that you've done regarding open government.
Well, I think open government in some ways is a special case, because I think a lot of the tools that you're talking about seems like a misfit for government data, right? A lot of, at least, let's say we're talking about our common law, federal court records, as we were talking about before. It seems like a misfit to say that here's a certain data release mechanism to see certain kinds of court cases when, you know, all of these court cases combined, you know, together make up the law that we as citizens need to comply with. And I think that the assumption when government publishes data that's public domain is that it doesn't come with, at least for some kinds of data, doesn't come with any kinds of licensing or terms of use agreements that these data ought to be usable in any way that the public wishes. And I think for certain kinds of government data sets that are like this, I think a lot of these strategies actually don't really apply well. And
public use data sets are not terribly useful for in-depth research. They're de-identified to the point where they can give you some very, very broad trends and things, but most researchers find them not terribly useful.
Right, so I think it depends on what the government sees as the beneficial downstream use. And I think the main problem is that within the government, there's just not enough expertise about how to think about a lot of these problems. I mean, there are a handful of people in this room that can do things really well, but they're not working, many aren't working in the government, and certainly there's so much government data out there that I think that we just need more expertise within government to be able to think more about, you know, how to release a lot of this data.
Yes.
Petra brought up is really one of the most important from my perspective, from my years at Citi, which was the relationship between the company, its research, firms that they hire, the marketing firms that they hire. How do you set up all those firewalls, and what information goes back and forth, and sort of what makes that vulnerable, and how much information, what the research house may need, may be much more specific than what the marketing people need. Otherwise, they won't get very good data. Somewhat, but I think that's something that Jules might want to build on. Is more the, in addition, is the identification when you go between the company and its partners.
Other questions, comments? Okay. Almost on time even. Terrific. Thank you so much again to our panelists.